My name is Robert Sand. I am a professor at the Vermont Law School and the founding director of the law school's Center for Justice Reform, which has now become the National Center on Restorative Justice under the leadership of Professor Stephanie Clark. Before becoming a full-time member of the faculty, I worked for 22 years as a prosecutor, 16 of them as the elected state's attorney, or DA, for Windsor County, Vermont. The views that I am about to express are mine and mine alone. What I wanted to do was talk about the criminal charges arising from the death of George Floyd and try to put those charges in the broader context of the law of homicide and in the specific context of the homicide laws in the state of Minnesota. A couple of disclaimers. I am not an attorney licensed to practice in Minnesota. I have never practiced in Minnesota. And so everything that I've learned from research that I've done about the laws in Minnesota. I welcome corrections, comments, edits to my presentation. The second thing that is probably painfully obvious to you right now is that the production values of this are going to be relatively minor. And in fact, I am recording this in my car adjacent to a public library, the only place I can get decent internet reception right now. I think that many people thought in the wake of the killing of George Floyd that it would be a long time before we learned whether any charges would be filed. And that was true because oftentimes criminal charges against police officers are never filed, and because in many states in more serious crimes, a prosecutor needs to present the case to a grand jury for a determination about whether an indictment should be returned. And yet, just a few days following the killing, we have criminal charges filed, third-degree murder, and second-degree manslaughter. So I had three reactions to that. First, that was done pretty quickly. Second, I guess Minnesota doesn't require the use of a grand jury. And third, what the heck is third-degree murder? So let me try to unpack those three issues. First, as to the speed of the charges. Filings by prosecutors are factual, legal, and social political decisions. And any prosecutor who tells you they're not factoring in the societal and political implications of their charging decisions either isn't being honest with you or with themselves. And it is certainly true that the filings that have happened related to the death of George Floyd have been influenced, I believe, by social and political forces. With regard to the requirement that Minnesota use or not use a grand jury, I looked it up, and it turns out that grand juries are required, but only in the context of cases punishable by life imprisonment. Now, with any luck, I'll be able to share my screen with folks, and hopefully you can see that. So, indictments under Minnesota rules must be returned for offenses punishable by life. Now, first-degree murder in Minnesota is punishable by life. So that would mean in order for prosecutors to maintain a charge of first-degree murder related to the death of George Floyd, they would need to present the case to a grand jury, a citizens panel, and that grand jury would need to return what's known as a true bill, an indictment on the charge. The fact that there hasn't been a first-degree murder charge, that we have not heard about a grand jury in Minnesota, doesn't prevent or foreclose the prosecution from going forward with a grand jury. We have not heard that that is their intention, and we may not, because grand jury proceedings are confidential. So the last issue, what the heck is third-degree murder? Stay tuned and we'll have a discussion about that. The law of homicide says that before a murder charge can be filed, there must be the existence of this thing we call malice. And put away any dictionary definition of malice. Malice is a term of art used in criminal law specifically related to the law of murder. And in order for an illegal killing to be murder, one of four situations must be present. First, there has to be an intent to kill, or there has to be an intent to cause serious bodily injury resulting in death, or there has to be reckless behavior that shows extreme indifference to the value of human life, or there has to be a death that arises during the course of a felony under this thing called the felony murder rule. If any of these four situations are present for an illegal killing, then it is a malice killing and can be treated as murder. If none of these four situations is present, then an illegal killing is not murder, but might be a lesser homicide, like manslaughter, or perhaps negligent homicide. So let's look at these four malice situations in relation to the homicide laws in Minnesota. And I'm specifically going to focus on the murder charges, though I'll touch very briefly at the end on the manslaughter charge. So first, is there an intent to kill? Well, here's the Minnesota statute on murder in the first degree. I don't expect you to read that. Here's the important language for our purposes right now. First degree murder is when a person causes the death of a human being with premeditation and with intent to effect the death. And that's a pretty classical or common phrasing, an intentional killing done with premeditation. What's premeditation? Means consideration, preparation, plan, really thought before acting. Now, the prosecution has apparently not sought a grand jury indictment on a charge of first-degree murder that Mr. Chauvin, the former officer, intended to kill Mr. Floyd after prior thought and planning. So, if first-degree murder is intentional with premeditation, one form of second-degree murder is intentional but sudden. Here's the second-degree murder statute, and here's the important language: causes the death of a human being with intent to effect the death of that person, but without premeditation. First-degree murder, intentional with premeditation. Second-degree murder, intentional and without premeditation, or intentional and sudden. That charge has not been filed. I told you earlier that one variant of of malice, is intending to inflict serious bodily injury that results in death. Does Minnesota recognize that as second-degree murder? Sort of. Minnesota says that intending to inflict or attempt to inflict bodily harm upon the victim can be second-degree murder. However, look at the language after the comma, when the perpetrator is restrained under an order for protection. So unless it is a situation where there is a protective order, an intent to inflict serious bodily injury that results in death is not second-degree murder under this language in Minnesota. And yet we know that there is a second-degree murder charge. So how is that accomplished? That is accomplished through the so-called felony murder rule. Under Minnesota law, it is second-degree murder if a person causes the death of another without intent, but that death occurs when the person is committing or attempting to commit a felony offense. Now, the charging document in this case does not specify what the underlying felony was that serves as the predicate, as the basis for the felony murder charge. And Minnesota Attorney General Keith Ellison was asked that question, and he said that it was a physical assault, a felony assault, that formed the basis of the underlying felony that then gets elevated under the felony murder rule to murder. Now, some folks might say, wait a minute, what about the so-called merger doctrine? The merger doctrine says there has to be a felony independent of the behavior that causes death in order for the felony murder rule to apply. And a physical assault would not serve as an independent felony under the merger rule. Well, the Minnesota Supreme Court has specifically rejected the merger doctrine. And in light of that rejection, that means that a physical assault could serve as the predicate felony for the felony murder rule. All right, so we have looked at first-degree murder, intentional and premeditated, no charge related to that. No second-degree murder related to intentional or sudden. No second-degree murder related to intentional intentionally inflicting serious bodily injury resulting in death. We have seen second-degree murder based upon the felony murder rule. That leaves one more form of malice, and that is a killing that is done recklessly under circumstances manifesting extreme indifference to the value of human life, sometimes known as a depraved heart killing. And the historical language got kind of flowery. Was the death committed by someone who had a heart void of social duty and fatally bent on mischief? Or did they have an abandoned and malignant heart? The contemporary phrasing is, was the killing committed by someone who acted recklessly under circumstances manifesting an extreme indifference to the value of human life? Now remember when I told you at the outset that I would tell you about third-degree murder? Well, here it comes. Minnesota is one of only 3 states that divide their murder laws into 3 degrees. Most states only have first and second degree. The model penal code only has murder and doesn't divide it into degrees, but Minnesota has 3 degrees, and third-degree murder is a so-called depraved heart killing. And it says whoever without intent to effect death does an act eminently dangerous to others, evincing a depraved mind without regard for human life, is guilty of murder in the 3rd degree. You'll note, to Minnesota's credit, they have switched what historically was called a depraved heart killing to focus on the mind, which is probably the more appropriate place to focus. Subsequent decisions have indicated that the standard here is effectively a reckless standard. So Minnesota's 3rd-degree murder is effectively a killing done recklessly under circumstances manifesting extreme indifference to the value of human life. So those are the murder charges in the context of the law of homicide and Minnesota law. An interesting issue arises, however. There is case law in Minnesota that says their depraved mind murders don't apply when the behavior is targeted to a specific or particular person, that statute is designed for recklessness generally, but not behavior focused on one individual or one victim. So what might be general recklessness might be driving into a crowd or dropping something off of a bridge or a building. So it will be interesting to see how the courts handle what looks like pretty targeted behavior by the former police officer directed to Mr. Floyd. So this is the caption heading of the amended charges, and this is the second-degree murder charge based upon the felony murder provision. And here's count 2, which is the so-called depraved mind or depraved heart killing. As you know, there also is a second-degree manslaughter charge, which is based upon culpable negligence. I think I will save for another day what the definition of culpable negligence is. Suffice it to say, it is a more serious deviation from a reasonable standard of care than ordinary civil negligence. A couple of other thoughts. The 3 other officers are charged as aiding and abetting Mr. Chauvin. And I want to suggest that there's another way to think about their behavior. Ordinarily in criminal law, doing nothing doesn't expose you to criminal responsibility. There is not ordinarily a legal duty to act. There might be a moral duty, but not a legal duty. The exception to that is where there is a duty created in the law. And if a duty exists and a person fails to act, their omission can serve as the basis for criminal charges. I'm not talking about a Good Samaritan law where anyone has an obligation to come to another's aid if they can do so safely, and they might face a misdemeanor, a relatively less serious charge if they fail to come to aid. I'm talking here about someone actually being responsible for the death of another person because they did not come to the aid. There may well be a statutory or contractual obligation on the part of police to come to the aid of citizens. And if that is the case in Minnesota, then the 3 officers who did not come to Mr. Floyd's aid may be responsible for his death based upon a failure to act rather than their affirmative assistance to Mr. Chauvin. It would not surprise me. In fact, let me predict that 1 or more of the 3 officers will resolve their charges based upon their omission or their failure to act rather than their affirmative aiding in the conduct by Mr. Chauvin. Lastly, and maybe most problematically for me, police responded to the scene because a store owner reported that Mr. Floyd passed or uttered a counterfeit $20 bill. And based solely on the word of the store owner, police approached Mr. Floyd's vehicle, pointed a gun at him, ordered him out of the car, handcuffed him, and killed him. passing a counterfeit $20 bill is not a crime in and of itself. I'm sorry. This is the slide that relates to Minnesota acknowledging that where there's a special relationship, criminal charges can be filed. Let me return now to the counterfeiting law. Counterfeiting law in Minnesota requires that there be an intent to defraud and that the person who passes the counterfeit money must have reason to know that the money is counterfeit. As far as I am aware, there was no investigation into whether Mr. Floyd intended to defraud anyone and whether he had reason to know that the money he was passing. If that evidence was not present in this case, then there was not even probable cause to arrest him. And as you will see highlighted at the bottom, the maximum possible penalty for this offense is 1 year imprisonment. And yet, Mr. Floyd ended up paying with his life. So I hope you have found this useful. I welcome any thoughts, comments, corrections. My contact information is on the first slide. Stay well, stay engaged, vote, peace.